Hey guys, welcome to today's webinar. I'm Chris Meyer. I'm with Green Spoon Martyr, and just a few housekeeping rules. We're going to put up a Q&A section at the end of the webinar, or I'm sorry, during the webinar. And while I'm going through it, feel free to ask any questions you'd like. And towards the end of the webinar, and it shouldn't take that long, probably about a half hour, 35, 40 minutes. I would be happy to answer the questions, any questions you may have. I'll repeat them so we all know what was submitted, and I'll do the best I can to answer them. Just quickly, a little bit about myself. I'm Chris Meyer. I'm of counsel with the law firm Green Spoon Martyr LLP. We're based in Fort Lauderdale, Florida, national law firm with offices all over the U.S. I've been practicing with GM for 10 years, almost 10 years now, and been in the field of consumer protection defense for the last 12 years. So that's a little bit about me, and would like to get on with our presentation for the day. And I really hope you guys enjoy it. But first, I've got to give this a little non-legal advice disclosure. Please take time to read that. Have to put that out there. Next slide, please. So a lot of companies market via outbound telephone calls and text, and there's a lot of reasons to do this. A lot of good, profitable reasons for companies to do this. As we all know, I think telemarketing has gotten a bad rap, so to speak, and I'll go into all of that. But what this presentation is mostly focused on, and some of you may or may not know, but these aren't just cold telephone calls. These aren't just, the old days where there's a bunch of telemarketers sitting in a boiler room and dialing off a list and bothering you during your dinner hour. These are calls placed to consumers that have already requested a call back or a text back. They're becoming much more commonplace for reasons I'll go into, but there's complexities in placing these calls. But just want to be clear, people can still make cold calls in very limited situations, but these are typically consumers who've expressed an interest in a certain service. Next slide, please. So I want to go over the problems with making these calls and sending these texts, and then I want to go through the solutions that companies can use to place these texts and make the phone calls as compliantly as possible. Pardon me. So there's a law out there that probably a lot of you are familiar with at this point. It's called the TCPA. It's the Telephone Consumer Protection Act. And I'm not, just to back up a little, I'm not going to go through a bunch of citations to laws and frankly case law either. It's a very general discussion on how to make these calls and how to place these texts compliantly. You can certainly talk to me after, consult, and I could give you all the citations and all the kind of boring stuff, but I just wanted to hit on the TCPA because these laws and other similar state laws allow consumers to sue telemarketers or sue companies that are calling them. And it's really caught on lately for the plaintiffs bar and for consumers. And there's a lot of damages out there that are to be had. And folks are exercising their rights to sue companies, that have called them illegally. Last citation here, frankly, on robocallers. This is from a Supreme Court case that was just decided a few months ago, and I really just wanted to bring the quote to light. It's by Brett Kavanaugh, which I'm sure most of you are familiar with. He was just appointed to the Supreme Court, but he said Americans passionately disagree about many things, but they are largely united in their disdain for robocallers. So that's kind of what we're dealing with here, but there's ways to navigate marketing this way and to do it compliantly. So next slide, please. So here's how it works usually, and some of you may or may not know this. In marketing via telephone and text, many consumer-facing companies they use marketing agents or lead generators or downlines. And that's a perfectly acceptable arrangement. And how the large percentage of those companies dialing out and outbound calling and texting consumers use these companies. So just to sort of paint a broad picture, pardon me, these companies will typically operate websites that are specific to certain industries. You have your healthcare industries, vehicle service industries, debt resolution oriented types of industries or spaces, whatever we want to call them. And the marketing companies will operate these websites. And what they do is they are there to attract and educate consumers about specific industries. And they allow consumers to go online and say, hey, I'd like a call relating to this specific industry. Next slide, please. So these are getting more and more popular because what happens, with consumers nowadays, they're much more inclined to go online and to try to buy services via Amazon. Whatever their service they're looking for, they go online. But there's services that are more complex, such as health insurance types of services or vehicle service contracts that still require a phone call. And those services, you'll have consumers going online and trying to buy this service over the phone, or I'm sorry, trying to buy the service online and realizing that they need to have a phone call to really clarify the services. They need to be sold over the phone. And I don't think it's a matter of a consumer saying, gee, I need to be sold over the phone. It's more the consumer saying, you know, after I've been online and I've been searching for these services and I'm kind of, chasing my tail here. I need to talk to someone to explain these services so I can make an educated purchase. But there's problems, and here are the problems in some of the with marketing companies and agents. One problem is, and this is a major problem in my opinion, is when the companies, the marketing agents, they oversell their leads. So this means that they'll have a lead, and the arrangement varies. Sometimes the marketing company will place the call to the consumer, educate the consumer on the services, and see if the consumer is interested in the services and actually make the sale, then pass them to the consumer facing company or the end line company, the company that's on the agreement the consumer signs. Or in some cases, the marketing company will simply provide data to the consumer facing company to call out to make the phone calls. But so those are some of the arrangements. But in any case, one problem is that occurs with marketing companies, marketing agents, downlines, is when they oversell their leads, frankly. So this means that you've got a consumer that went online and he just ultimately, he or she wanted a phone call so they could understand the services over the phone, ask all kinds of questions that they may have about sometimes complex services. And they click this consent to say, I want to call back and I want to learn about this. I'll talk a little bit about the consent language in there. But unknowingly to the consumer, when they click the button, if their lead or this opt-in is oversold, they're going to get a bunch of calls from a bunch of different companies, all likely trying to sell that consumer the same thing, and that's fine. And they may tolerate a few of these calls, but after a while, they frankly get angry and they tell the companies to stop calling them. Now, that's a problem because when one consumer or when a consumer that's been getting called by a bunch of different companies tells one company to stop calling, well, that company may stop calling, but the other companies that have been sold that lead may continue to call the consumer. And that winds up in, frankly, in an irate consumer getting a lot of phone calls. And that's the consumer that either decides to sue a company by themselves or send a demand letter, or go to a regulator, complain this, I've been getting called left and right by these certain companies, or ultimately go to a TCPA lawyer and file, what can be a pretty significant lawsuit against a company. So those are problems with oversold leads, and the DNC problems that can occur. It frankly just winds up in a consumer that's gotten called way more times than he or she bargained for, and they're frankly not happy about that, and they take action on that. Quick point on the consent language issues. So the TCPA and many of the state laws that are state telemarketing laws that are similar to the TCPA require companies to actually be named on the consent. So when the consumer opts in for a phone call, presses the button online, submits his or her information saying, I want to call back, then the company, the end line company, really all companies involved in the call, need to be listed. And so, and there's also some very specific language about auto dialers and texts and ringless voicemails that need to be on there on the consent language. And those are typically in the consent language, but those are issues that sometimes come up if companies are not listed and the consumer gets called by a company that's not listed. Next slide, please. So dovetailing on the last slide was, and these are more problems. And by the way, I'm going to present some solutions, and I should have said that at the very beginning of the presentation. I want to lay out the problems, hit you with the bad news first, and then there's good news to this. So these are more of the problems, and I just want to point out the risks here, so we all know kind of what we're looking at here. So there's a growing number of telemarketing attorneys, and what I call do-it-yourself consumers, and they don't use attorneys, and they do things pro se, and that's fine. They have every right to do that. So there's a growing number of them that are do-it-yourself consumers, do-it-yourself lawsuit filers, if you will. And what they do is they'll get calls, and they'll allege that they were unlawful. Many times they aren't, many times they are. Really impossible for me to say how many are or how many are not. But they'll want money from the companies that called them, and they'll send them a nasty demand letter. Sometimes it's a cut and paste from the internet. And they'll want usually $1,500 per call. Also, there's a growing, to compound this problem, there's a lot of telemarketing attorneys. They file their lawsuits as class action lawsuits in federal court. That's a problem. What I call it, ratchets up the damages for their clients. These cases, telemarketing cases, TCPA cases, frankly, it's kind of created a perfect storm for plaintiffs' telemarketing lawyers. And the telemarketing claims, they're sort of easy, for lack of a better term, to place into a class action lawsuit. So they'll file the cases as a class action lawsuit. Doesn't mean that it's a class action lawsuit, it's a bona fide class action lawsuit. In order for that to happen, you need a judge to sign off on it and certify it as a class. And there's a lot of work involved in doing that. And there's a lot of defenses that can be put up for, but a little more detailed than we care to get into here. But the point is, they file them as class actions, and then you go to settle them out as the defendant's attorneys, as the clients, as the target's attorneys. That's what we do. We're defense attorneys, and they say, hey, we can we'll gladly settle this out on an individual basis, not as a class basis, and we'll just make it go away real quick. But we frankly want a lot of money, because if you don't want to settle it out now, here and now, well, then we'll just carry it on as a class action. And that's a real problem for the company that's been named if there's a little bit of liability on their side, or frankly, even if there isn't. because then you're looking at 4 years worth of, in some cases, 4 years worth of phone calls, and a class, whether on their the do not call list or they were called illegally on with a computer, the auto dialer class, you're looking at, 4 years worth of calls and anywhere between $500 and $1,500 per call. So it's astronomical. And so there's a lot of damages that are on the table if you get sued with a class action lawsuit on TCPA and it's carried through. So that's a problem. Also, there is consumer fraud out there. There's fraud everywhere. I'm not sitting here saying everybody or the vast majority, or I'm not even giving a number, frankly, of consumers who say they did not opt in. This situation has sort of made it right for consumers to just, again, it happens. Frankly, go online, request a call, and get phone call and say they never did it, and file a lawsuit. So there's a lot of defenses to that. You'll have a valid opt-in. They can be litigated, but it costs money to fight back on those. So those are sort of the problems with that are out there with telemarketing texting. Next slide, please. So there are some solutions, and so and here's the good part. There's light at the end of the tunnel, if you will. So you can, companies do successfully market via outbound calls and texts, and the way they do that is they can mitigate their risks in several ways. Here, and I've got them outlined here. I'd say less is more. So backing up to the part where I said that the leads are oversold, the less leads that are sold from one particular opt-in, the better. As I'm sure you can imagine, these types of leads get more expensive. Can't certainly get into what it costs per lead and per acquisition and all those things. It's sort of beyond the scope of the presentation, but yes, they can and are more expensive, but they're better because then you have a consumer that's not getting overcalled. He or she didn't press the button and they got called by 20 companies. They're getting called by one or two. Your company, that may be the end company here, they're getting called by that company. So hey, if the consumer says stop calling, that's easy. Stop calling this guy, put him on a do not call list. He doesn't get called again. Lead is dead. Everybody's happy. So that's one major way to mitigate your damages, to mitigate your risk, I should say, on telemarketing via outbound calls or text. Also, I've got here the more information, the better on opt-ins. So opt-in websites are the websites I referred to earlier, where consumers go on to websites that are usually specific to certain industries, requesting information, and they put their information into this website or a website. And the more information that the marketing company or the lead generating company or any company who's operating a website, frankly, the more information they can capture on the consumer, the better. So you want all the information that the consumer submitted onto the website, name, age, type of car, health problems, whatever they put onto the website, whatever it's asking for, you certainly want all that. You want the IP address of the consumer who made the opt-in from his computer, his or her computer. You want to capture that IP address. It'd be good to have an archived version of the opt-in when it occurred, because sometimes these opt-ins, the consumers go on, a long time in the past, years ago, and a phone call is made a couple of years ago, and these lawsuits and claims surface 2 or 3 years later. The consumer decides to allege a claim, and this is kind of old, dated information. So you want an archived version of the website of what it looked like, what displayed on the website when the opt-in was made. I've also seen operating systems captured, so the consumers operating system, whether they're using a Mac or Windows or whatever operating system they have, the version they have. So this is all good stuff, because when we go back to the consumer and say, hey, wait a second, or the consumer's attorney, and say, wait, you opted in, and we have an opt-in here from you or from a person saying it was okay to call this number. So, frankly, go away. And also we have an operating system, and your client, or you were using a Mac 0.20, and what do you use? And so you can drill down with all this information to defend yourself, and to say, hey, you opted in for the phone call. I've seen out there online videos of the opt-in occurring in real time. When I first heard of this and I hadn't seen it yet, I thought there would be a video of a person sitting at their computer opting in. It's not quite that good. And maybe that wouldn't be such a good thing anyway. But all kidding aside, there's a video of the actual opt-in website. So you will see the consumer opt in and fill in the fields and click I submit and the consent language and all that good stuff. You'll see it in real time as the consumer opted in. So you've got if you've got something like that and you get a TCPA complaint or a lawsuit or some type of regulatory issue from a consumer that alleges that he or she's been called illegally or unlawfully, and you can come up, you can show them a video of the person opting in. That's pretty compelling to defeat the claim. So those are good things to have, and to really mitigate your risks in this space. So get the next slide, please. So also there's also, this sort of also dovetails into being oversold leads. There should also be a way where the consumer, if they say stop calling to any one of the companies that are calling them or being pitched on a call, if they say, hey, stop calling me, then that number needs to not be called again. That probably may sound obvious to some folks, but the problem, going back to the oversold leads, is that if you have data or information out there and you have 10 different companies calling the same consumer on that one opt-in, so the consumer says, stop calling me to company A, but company B, C, and D, and E are still calling them. Well, after they say, stop calling me company A, fine, company A says, I'll stop calling him. They put him on their DNC list, call stop. Company B, C, D, and E still call. The consumer is going to get upset and likely complain or file suit, go to a regulatory AG, something like that. But the real problem is that company A, who may have named themselves and said, hey, this is company A, it's their full name, we're located at this address, would you like our services? No, stop calling. Okay, thank you. If the consumer only knows company A and he or she continues to get called 2 weeks, 3, 4, 5 months down the road, and the only company he or she knows is company A, guess what? Company A is the one who's going to get the complaint, and they very well could have been the ones that that truthfully DNC'd that number. So there needs to be a mechanism in place if the lead has been sold to several companies to call, where that number is not called anymore by anybody. That's sometimes a little difficult to make occur, but that's really important to mitigate your TCPA risks here. Also, and this isn't support of any specific companies that provide these services. It's not a recommendation. As you can see, I don't have anybody named there, but there's companies that provide litigator lists, and what they are is they're they're frankly DNC lists, not any state or federal DNC lists where consumers go on and put their numbers. That's another story that every company or another regulation that companies need to scrub against. That's if they're cold calling, but that's backing up a little. But these litigator lists are phone numbers that are known litigators, and I've been told there's my understanding, I've never combed through one, but there's several thousands of these numbers on this list or lists. They are updated regularly, and they are known litigators. They are known consumers who either likely file TCPA lawsuits, or I think they started in the FDCPA world. That's the collection world, where consumers would sue collectors who called them illegally. But there's TCPA lists out there. There's lists that are mixed with both, but they are phone numbers of known litigators, and so you don't call them. So to play that through a little, you get a lead, you get an opt-in from a phone number of a known litigator. You don't call that number, even if it's a great opt-in, and I really want to buy your services. Call me. You don't call them for obvious reasons. But the issue with those is that the end companies, and I'll say the consumer-facing companies, they need to be in a position where they can make sure that the litigators list is being used. If they're not dialing, if we have an arrangement where the marketing company is actually calling the consumer or texting them, then the end company should have in their agreement that the lead generator company is going to use the litigators list, and a reputable litigators list, update it, and use it, and make sure if any leads or any opt-ins come in with that number, make sure those numbers are called. So that's a biggie in helping to just cut a large amount of these risks down. Next text, please, or next slide, please. So also, and this is probably, pardon me, this is probably a little bit obvious, but the companies, end companies, and looking at it from their perspective, this presentation is sort of geared towards that. They need to have solid agreements in place with their lead generating companies that are very specific, that say the lead generating companies or the marketing companies are going to operate compliantly, and they're going to do everything they can to operate compliantly within the TCPA and other state telemarketing laws. And they need to be really, frankly, as specific as you can get them. They should speak to overselling leads. They should speak to how a company will use a litigators list. All those things are very, very good things to have in place. Within those agreements, is this sort of goes with what I just said. You're going to want the company, the end company, since they will call it the consumer-facing company, is going to want a real strong indemnification agreement in place to say, hey, if you pass me a lead, or you call a consumer on behalf of me, or you give me data and I call a consumer pitching my services, and that consumer turns around and says this is an unlawful call and I'm going to sue you, and it's going to make a huge case out of it. You need to, like I said, have an indemnification agreement in place that says the consumer-facing company can recoup its fees, however you want it worded, or however it needs to be worded, to say that the marketing company will essentially cover the consumer-facing company's expenses for the unlawful call, if in fact, they breach their agreement in giving you, frankly, a bad lead or a known litigator, or so if they breach the agreement. But that's important to have in place. Now, my last point here: these agreements, they're not, and I put it as a get out of jail free card. meaning they're not quite that. They're really not that when it comes to a lawsuit. So just to sort of paint a picture, if I'm representing a client and it's a ABC company, and ABC called Mr. Jones, and Mr. Jones is suing, and Mr. Jones has got a nasty, he filed a nasty lawsuit against ABC, and ABC says, hey, wait a second, I am, pardon me, I've got a, I'm sorry, I've got an agreement. ABC has agreement with the lead company that says they were supposed to do things compliantly. So ABC gives me that agreement, and as their lawyer, I get on the phone with opposing counsel and I say, hey, I have they have an agreement here that this company, they use this company for marketing purposes, and they were supposed to do everything right. And I guess they called your poor client, and I guess I guess it was an unlawful call, but it wasn't their fault. It's not going to get you very far in getting out of that lawsuit out of the gate, I call it. It's helpful. It's helpful for the consumer-facing company, ABC company in this example, to potentially get their money back from the marketing company. But as far as plaintiffs go and plaintiffs' attorneys, they don't really care too much about that. And they're going to say, well, that's nice. That's not our problem. You called our client and we want money from you. Now, I say out of the gate because they don't go very far in getting things settled quickly. And that's, I always like to do that if that's a potential for our clients, is to settle it quickly. These types of agreements that I'm talking about on this slide, they can eventually be used effectively to litigate the consumer-facing company out of a case on an agency theory. There's some very good case law out there that companies have gotten dismissed from these types of lawsuits based on the fact that they had a solid agreement in place with their marketing company, and their marketing company went off the rails, and so they got out of the case. But I can tell you that's not going to happen for a little while. It takes a lot of discovery. It's going to be frankly a long road. It's good to have. It's very good to have. It's a very good defense. But it takes a while. If the plaintiff's attorney or the plaintiff wants to really litigate the case, I'm talking frankly about a class action case. They're good to have, but they're not going to get you out. It's not a phone call. So I hope that paints a picture on those. Next slide. Okay, that wraps things up. If you have any questions, there's a Q&A, and I think I have a few questions here. I think I've got to click on this to get it. Okay, so I've got a couple of questions here. Bear with me. I'll repeat that. First question, it's a good one. How long do you have to call someone after they submit their opt-in? So that's a really, really good question. I'll just go ahead and answer this rather than typing it to where it can be seen. But so the answer is there's no time limit on it per the consent and per the TCPA. But pragmatically, you really shouldn't let these opt-ins go longer than really a couple of months. Like anything in this industry, it gets more expensive. So fresh data, fresh opt-ins are more expensive. You have these things called aged data, which hangs around for a while, and you'll see opt-ins that are 2, 3, 4 years old, and hey, call this, and this guy wanted a phone call on this 3 years ago. Well, that's not going to be good, because the odds are that guy's been called a million times, and he told people to stop calling him years ago, and now he's PO'd that he's getting called 3 years later. So question, I think a good rule of thumb is to really, if you can do it, is to not really let it go past a month or so. So that's just a sort of a rule of thumb. Next question, what is the difference between a $500 call and a $1,500 call? Good question. The TCPA allows for $500 in damages if it was a negligent call, and $1,500 if it is a willful call. So, as I'm sure you can imagine, the folks that are coming after you for making complaints saying you called me unlawfully, or the lawyers are the lawyers that are coming after your company wanting damages, filing lawsuits, they're always going to go for the $1,500. There's a lot of case law on what determines what's negligent and what's willful. It's not, of course, companies always say, geez, I didn't know, I didn't know I had to do this. That's why I called this guy. That's not necessarily going to get you into the negligent area. It's not too hard to get to the willful damages, and the willful are $1,500 a pop. You should have known if you're outbound calling consumers how to comply with these laws. It's not that hard of a threshold to get to $1,500 a call. But that's a general response, a general answer to that question. So what does a consent have to say when someone goes online and asks to be called? That's the next question. The consent needs to be very specific that the person making the opt-in, the person putting in their information, that they are allowing themselves to be called by use of an auto dialer. They're allowing themselves to, they're consenting to them being texted by an auto dialer would also be good. And they're allowing, if ringless voicemails are in the mix, they're consenting to receiving a ringless voicemail. And they're also, as far as SMS text goes, they're saying that they're okay with the data rates applying to their bills on this. And they're also saying that it's not necessary for them to make any purchase by submitting their opt-in. Those are sort of the biggies. We certainly have language that I've been working on over the years. It's compliant with TCPA, and it's gotten over a few lawsuits we've seen that it's good to put this and that in there. But the gist is to be called by an auto dialer, to be sent a text, to receive a ringless voicemail, and also very important that they're consenting to getting a call even though they may be on a state or federal do not call list. You have these do not call lists that are set up federally, and often many states have them, where consumers put their phone number on there. You've got to have language in there that says, hey, it sounds obvious, but it needs to be in there that says, I'm okay being called even though my number's on a DNC list. This way they can't come back to you and say, oh wait, I was on the DNC list and you called me. Well, you said we could call you even though your name is on the DNC list. Next question, good one. Who are the providers of the litigators list mentioned earlier? Give me a call. Give me a call on that one. Whoever submitted that, I'd be happy to talk to you about that. And we got one more here, I believe. I'll read it out. How would liability typically work if an independent insurance agent purchased the leads themselves, but called a client attempting to sell the company's products? Not sure I follow that one entirely, but I'll try to. So if an independent insurance agent purchased the leads themselves, so they got a group of data, hopefully that data, anyway, you were told it was okay to call these consumers via an auto dialer, if they're on the DNC list, all this stuff that I just talked about. So if it works this way, if they call the consumer and they get the consumer on the phone and the consumer is savvy and is one of these litigators, frankly, the consumer will play along, if you will, or feign interest is what they like to call, and they'll act like they're interested in the service, and they'll frankly make a purchase sometimes, and then they will turn around and say, hey, I did not consent to being called by an auto dialer if the agent used a computer to make the phone call, or more importantly, if it's just an independent insurance agent. And I'm trying to maybe embellish a little more on the question. If it's an independent insurance agent just simply sitting at his phone and calling, then that consumer who got that call would likely say, you called me and I'm on the DNC list and you're not supposed to do that. And the DNC will also give him or her damages of $500 or $1,500 willful. So your liability lies there. Now, for the guy, for the man or woman or the insurance agent who made that phone call, that's kind of, frankly, really, it's kind of a bummer for him or her, because here they bought this data, or they purchased this data, this lead list, thinking it was compliant to call, and it wasn't. And here they get hit with this claim, that they need to go back to who gave them that data, try to recoup that money, try to offset the liability. Frankly, in a situation like that, I think it's sometimes best to move on, pay the guy off, enter into a settlement agreement, confidentiality clause. He can't talk about it, go away, we part ways, and then, try to recoup the funds from whoever gave you the data. So I hope that helps. I think this probably is a little further dovetail on this, on the last one. Can the upline general agent or insurance carrier be held? Yeah, great, very good question, actually. Can the upline general agent or insurance carrier be held liable for the question above? Yes. And that's the problem with a lot of these TCPA cases. So anybody pitched on the call can be held liable and per the TCPA and is. And so to talk a little more about that, in the example I just cited, you say an independent agent calls the consumer, gets the lead list, calls the consumer, however he does it, he dials it with his computer, hand dials it, whatever. The guy's on the DNC list. He comes back and he says, hey, you called me, I'm on the DNC list, but he first played through and he got a policy in this case. And on that policy is, there's the carrier, the agent, you name it. I mean, even collateral service providers, people that, companies that you wouldn't even think, pick your poison, whatever collateral services may be sold. They're all liable. And oftentimes when these lawsuits are filed, as I'm sure you can imagine, they're all named. And so that gets everybody concerned and worried and wanting to settle it. I'm sorry. And these litigants, the telemarketing lawyers and the pro se folks and everybody who brings these, they know that that's an old maxim of law. I mean, you throw as much to the wall and kind of see what you can get out of it. But to answer the question, yeah, they are. There's ways to work them out of it. On the agreements part the slide that I talked about earlier about agency, and you never gave this agent the authority to go off the rails and just cold call the whole country. Those are defenses, and they're valid defenses, and they can be parsed through and effectively used to get carriers or any uplines out of the lawsuit or out of the claim. But yes, the liability is there, and it's often used to get as much money, frankly, as you can out of these. So hey, I think that's it. I guess we went about 45 minutes. I really appreciate it. Thanks guys for allowing me to give the webinar. I hope it was informative. I try to keep it real general. Listen, here's my contact information. If you ever have any questions, feel free to give me a call. Love to talk to you. If you ever have any issues or problems or compliance problems, please give us a call. You know, the best way sometimes to work with these things is to, you know, get ahead of the ball and make sure your documents are in order. And I can, you know, I like to think I can give you really some good pragmatic advice on this and not just, you know, rearrange contracts to kind of, you know, really give you a heads up on how to avoid this stuff, because it's avoidable in a lot of cases, and it's no fun when you get caught up in it. So, hey, thanks very much. I hope you guys have a great weekend. It's a little early. Again, thanks very much. I appreciate it.